Hey guys, with just 3 days to go now before the beginning of the Delphi trial, there's been some surprise filings by the defence. They're certainly going to come out swinging, especially as they've had a bunch of stuff banned from presenting in front of the jury. So this is very interesting. So these documents were filed yesterday. These are motions for transport for various inmates. So they're all worded the same, so I'll just read one and then read the names out for the next. So comes now the defendant Richard M. Allen by counsel Bradley A. Rosen respectfully requests that this court issue an order directing the Carroll County Sheriff to transport inmate James Hass to the Carroll County Courthouse to appear and testify at the trial in the above referenced cause. In support of said motion, defendant Allen states the following: the jury trial in this case is set to commence on October 14th. The defence intends to call inmate James Hass as a witness in this case. However, due to the volume of witnesses and due to the fact that the defence will not be able to present its evidence until the state has completed presenting its own evidence, it's somewhat unpredictable as to when inmate Hass will be needed in the courtroom. The defence requests that this honourable court issue an order directing the Carroll County Sheriff to retrieve inmate Hass from his respective facility. Attorney Rosie has communicated with Deputy Attorney General Aaron Ridlon, who represents the Indiana Department of Corrections, and confirmed that the Indiana Department of Corrections requires a 24-hour notice period for any inmate being retrieved from the Department of Corrections and transported to the Carroll County Courthouse. Therefore, Defendant Allen requests that this transport order articulate the circumstances referenced above and to provide some flexibility to the defence, the Carroll County Sheriff and the Department of Correction in transporting said inmate in a manner most efficient and most cost-effective under the circumstances. And then that's just the certificate of service. Now, James Hass. Who's James Hass? The name rings a bell. Is he the guy that said that Ron Logan had confessed to him that he'd done the murders? Is he the guy? Let me know. Because the name does ring a bell. Is he someone that Ron Logan shared a cell with? So let me know, you Delphi aficionados. So this one, all worded the same, except for the name. This is a transport motion to transport inmate James Chadwell to the Carroll County Courthouse to testify as a witness. James Chadwell, well, he's a suspect, or at least he was a suspect in the eyes of a lot of people. I don't know how serious he was looked at by law enforcement, but he was looked at by people. You know, a lot of people thought that he was Bridge Guy. So how interesting that he's now been called as a witness. Then we've got this dude. Now, I've never heard of this guy. I do not know who this guy is. So if anybody can tell me who this guy is, I'd be grateful. Ricky Davis Jr. Again, same text. Transporting him to be a witness. And then, finally, perhaps you don't need to be too much of a Delphi aficionado to know this name. Kegan Kline. Kegan Kline being called as a witness. Kegan Kline. Now, he's one of the banned names, so he won't be able to testify in front of the jury. So presumably, he is someone, maybe they all are, someone that the defence wants to present outside of the presence of the jury. If so, why? Is it to create an appellant record? Is this clever lawyering? I don't know. Let me know what you think. This has knocked me a little bit sideways. Now, this came out just today. Literally just been filed. Motion in limine. Defendant Richard M. Allen by counsel Bradley A. Rosie moves the court to do the following. Defendant Allen is charged with 2 separate counts of felony murder pursuant to Idaho Code 3542(1)(1) brackets 2. Defendant Allen has reason to believe that the state of Indiana may seek to admit at trial this cause testimony from various prison guards, inmates, law enforcement officers, and possibly the testimony of other Indiana Department of Corrections staff members as to Defendant Allen's mental state during his detention at the Westville Correctional Facility and Wabash Valley Correctional Facility. The defence believes the state's offering of said testimony may be driven by the desire to use said guards, inmates, administrators and law enforcement officers to establish the veracity of alleged incriminating statements made by Defendant Allen. The specific individuals have been identified on both the state's witness list and the defence witness list, which were exchanged between the parties prior to the filing of this motion. The defence desires not to list each and every witness in this motion so as to maintain some confidentiality, taking into consideration the public interest in this case and the forthcoming trial. The defence will offer up the names of said witnesses at a hearing on this motion or a pen request by the court, whichever applies. Defendant Allen believes that such testimony would violate Rule 701 of the Indiana Rules of Evidence. The witnesses do not have sufficient life experience that would permit making a judgment as to the mental state of Defendant Allen on the dates and times in question, or on any date and time before or after Richard Allen's arrest. Said testimony would violate Rule 702 of the Indiana Rules of Evidence, as the prison guards, inmates, law enforcement officials, and some of the administrators have no expertise in the field of mental health and therefore are not qualified to draw such conclusions. I agree with that. I absolutely agree with that. Said testimony violates Rule 704 of the Indiana Rules of Evidence, as the testimony amounts to the witness drawing an opinion on an ultimate issue, i.e. whether or not the witness believes the defendant Allen is guilty of the charged allegations. And that certainly would be wrong for prison guards, surely. Finally, said testimony would also violate Rule 403 of the Indiana Rules of Evidence, as it tends to be confusing and misleading to the jury due to the lack of expertise in the field of mental health with regard to any of the referenced witnesses, and such evidence is not necessary for a full and fair determination of the facts in this cause. I do agree with that. But you know what Francis will say? All say after me.
Denied.